Kleh, visiting professor in international law. Before I provide you with a description of Mr. Hall's extraordinary legal background, I want to thank Bill and Patty Kleh for establishing this distinguished professorship. Unfortunately, they couldn't be here today, but I do want to acknowledge them. Bill is a 1971 graduate of the law school who remains very much involved with BU as a university overseer, a member of the Dean's Advisory Board, and a sponsor of the Kleh Family Foundation lecture series in London. During his legal career, Bill served as general counsel of A Management Group and headed the company's international operations in London. When the company merged with Invesco, he became general counsel of the new company, which is now one of the largest investment managers in the world. Since his retirement in 1999, he and his wife Patty continue to run the Kleh Family Foundation, which funds educational projects that support international dialogue. Andy Hall, our speaker today, has a compelling message about the power of the law on an international stage. Mr. Hall, who is here all week advising students, sitting in our classes, and meeting with faculty, will speak on the topic of taking on state sponsors of terrorism, a new frontier in international tort litigation. He comes to us with a track record of winning international cases that have stemmed from some of the world's most significant events. In 1992, after the first Gulf War ended, Mr. Hall successfully litigated a case against the Iraqi government on behalf of an American contractor who had been working in Kuwait when he was kidnapped and tortured by Iraqi guards. In that case, the contractor received a $1.8 million settlement. After the bombing of the USS Cole in 2000, in which 17 American sailors were killed and 39 were injured, Mr. Hall recovered a multi-million-dollar payment from the government of Sudan, which was held liable for the attack. In one of his more recent cases, he won a $2.8 billion judgment against Cuba for the family of a Cuban businessman who was forced to commit suicide by the Castro regime and whose family was terrorized by the Cuban government for decades. As a Holocaust survivor himself, Mr. Hall's relentless pursuit of the perpetrators of state-sponsored terrorism has been more than a career calling. He was born during World War II in a coal cellar in Poland, while his parents and brother were hiding from the Nazis. After his father was arrested, Andy and his brothers were sent to an orphanage and didn't see their parents again until well after the war ended. Today, Andy resides in Miami, where he is the founder of the law firm Hall, Lamb & Hall. His casework has involved complex commercial litigation, professional negligence, securities litigation and arbitration, family law, personal injury, and wrongful death. And I'd like everyone to welcome Andy to the podium.
I'd like to start by thanking the Dean and all the other members of the faculty and staff of this law school and tell you how absolutely wonderful it is to spend this time with you. Because you work here and this is your business and personal home, you don't realize how extraordinarily welcome and kind it is to come into this environment and to be exposed to the exceptional law students that are attending school here, and the great law school that you created and the great message that you deliver. So in some way I get to bask in your shadow today, and I want to thank you for that experience. Now I want to talk a bit about the subject. And talking to an audience filled with faculty and staff is a challenge, because there's no question that in each of your respective fields you're undoubtedly infinitely more learned than I am practicing law and doing this every day. So you kind of require me to step up a little bit and be at my best game today. I'll try to do my best. But I also want to thank Bill and Patty Kleh for the opportunity. And I will confess to you, Bill's a great friend of mine. And when he and I were talking about creating this thing, I thought that was just a brilliant idea. And then after this particular visiting professorship was created, he said, "Who would you recommend?" And I gave him 3 names. And he came back a couple of days later and said, "Well, actually, who else would you recommend?" And I gave him 2 more names. And the 3rd time, he kind of suggested, "You don't get it, do you?" Obviously didn't get it. And he said, "Actually, I'd kind of like you to be the first speaker." And I said, "Well, can't you get somebody really good?" And he was very kind to basically tell me to know that I was the one he would really like. And Dean O'Rourke was kind enough to give me the invitation to come. So let's talk about the issue of state-sponsored terrorism and victims. this is an issue that actually didn't exist until the last 15 or 20 years. We had terrorism, to be sure. We had victims of terrorism, and we had states that were actively involved in creating acts of terror. But in terms of actually dealing with it in an American courtroom on behalf of a victim, that was simply something that didn't occur. So at the very beginning of this exercise in 1992, I found myself responding to a telephone call with a completely blank legal slate, meaning no precedent, no direction, and totally in the dark, or perhaps in the light if you're creative enough, in terms of what are we going to do with this thing? I got a phone call from a friend of mine in Houston, Texas. He told me a story. He heard Dean O'Rourke talk about Chad Hall. Chad Hall was an American contractor. He was hired to work in Kuwait to take unexploded munitions and disarm them. They carefully marked the border. He was on the Kuwait side of the border, and on a day, 100 yards from a Pakistani company of peacekeepers, Jeep drove across the border from Iraq. 2 Iraqi officers, armed, pulled their weapons on Chad Hall and kidnapped him, took him across the border and tortured him for the sole purpose of obtaining America's nuclear codes. Hall was, he's no relation. He was in custody for about 5 days. And in those 5 days, they absolutely engaged in any form of torture they could, and it was unsuccessful. Ultimately, he was released through the efforts of largely Queen Noor of Jordan. When he came back to the United States, he thought that there was something wrong about this, and he spoke to a colleague, friend of mine, who I worked in these cases with, Jim Kubero, said, "What can we do about this?" And Kubero said, "Well, I don't know, let's call Andy Hall." So he called me, and I did what all lawyers do. I did legal research, and I found that there was actually only one case in which there was an attempt to proceed in a civil action for what was essentially a violation of international law, Prince versus West Germany. Prince was a case where an American, unfortunately, an American Jew, was in Poland at the time of the beginning of the hostilities of World War II. He was arrested, he was incarcerated, he was sent to Auschwitz. He spent the war in Auschwitz. He survived, and then years later he sued West Germany, contending that based upon reunification, West Germany was now Germany, and there should be a responsibility for this violation of international law. And a district judge agreed and said, yes, I have jurisdiction. With that opinion in hand, I proceeded to file my case in the District of Columbia, but I got a different judge. And the judge that we got said, are you kidding me? This is not within the Foreign Sovereign Immunities Act. And because it's not in the Foreign Sovereign Immunities Act, and because the foreign sovereigns, as well as the United States, is exempt from lawsuits unless there is a specific exemption, we're going to dismiss. We took the appeal. And in the appeal, the DC Circuit, the panel was very kind. They appreciated the problem. They thought there was something really significant about it, but they said, but you know, you have to go to Congress. So we did. And Jim and myself and a whole lot of other people spent the next 4 years lobbying in the United States Congress so that there would be an exception for victims of terrorism, which ultimately ended up being an amendment in 1996. Largely that was an effort for the Brothers to the Rescue, that death. For those who remember that episode off the coast of Cuba, the Oklahoma City bombing people were lobbying for the same thing. That was thought of as an act of domestic terrorism. The victims of Panhandle 103 were lobbying because they wanted to proceed against Libya. And the first case that was filed after that was my case, which was filed under a man named Daliberti, who was also held hostage in Iraq. So that's how we got into it. But first question is, here's a statute, what does it mean? And we found very quickly that there were 2 points of view relative to this law, and the differences are hugely important. There was a group of judges and lawyers, including me, that thought that this amendment for terrorism contemplated either one of two things. Either there was jurisdiction and the statute also included the claim, so that if you could sue for that event, and the question of jurisdiction and the question of liability were all built into the same question. And there was a different view that said, no, it was only an empty jurisdictional vessel, and you had to find your law someplace else. It was that second group that prevailed. So the law evolved, and the next question was, what is terrorism? And I thought terrorism was something that we all recognized, because it turned out that wasn't an adequate area. So we got into defining terrorism. And terrorism is now defined in a very specific way to make the distinction between something more than police brutality, but has to be a severe, systematic effort to inflict emotional or physical pain on someone for an improper purpose, either to exact a confession or to avoid harm to another, or things like that. And now the statute has in it a right, so that if you are the victim of kidnapping, torture, killing, those things, you now have the ability to sue in an American courtroom. But the law is a dynamic thing, because the ability to sue doesn't mean you're going to be able to sue, because in the final analysis, there is one missing ingredient in all this. It's called evidence. And we kind of forget that sometimes, because the law is about people, it is about harm, it is about proof, and it's about how to basically achieve a just result when the law recognizes a claim. So what I thought we would do today, we use the bombing of the Kleh as a little bit of a peek behind the scenes of how that case actually developed. Hopefully that way it will be not entirely boring, and we can get down into some anecdotal things. I'll tell you some of the more difficult things that we faced and how we overcame them. And then we'll go in and we'll ultimately talk about the difficulties of getting paid, which is the final step in the proceeding. I want to digress for half a second, because the students at this law school are so talented, and because they're talented, they actually know how to ask exactly the right questions. Last night I had dinner with a number of them, and one student asked the right question. Here's the question that was posed. Isn't it enough just to know that you had a form to express what happened to you and to know that somebody said there's culpability and responsibility? Isn't that enough? And while it sounds like it might be, the truth of the matter is, in the real world terms, it's not. Because every time I have been in this area, and every time you get into, I want vindication of this terrible thing that was done to me, 24 hours after the award is rendered, the phone call is made, how am I going to get paid that money that's owed to me now? So the fact of the matter is, they are relevant because the money is the medium by which obviously we compensate people for the terrible thing that's happened to them or the people they love. And so the money does become important. So let's just run this, and I want to talk about the Kleh in this context. So let's start with the first step. I've made use of the History Channel's rendition. This is the Kleh. It's an archive film, which was a destroyer class vessel as it appeared before the bombing. And then we can go to the second clip. Let's go to the next one. Now, most of us realize that when the events of the Kleh were going on, the Kleh was entering Aden Harbor in Yemen, which is on the bottom end of the Saudi peninsula. That is the place in which the Kleh was refueling. At about 11 o'clock in the morning, a boat, shown here, with two men aboard, approached the Kleh. It was loaded with explosives. Nothing sinister about it other than two men are coming across the road. You'll see they were waving. Or in fact, they were indeed waving. They were greeted by the sailors. Hello, how are you? Nice to see you. A very typical American greeting. And even though they were armed and could have held these sailors significantly at bay, they did not. The boat proceeded along the side of the vessel. The explosion went off and tore a hole in the side of the hole of the coal that was 18 feet wide. We can just put that down. Thank you. What you don't know about an event like this is actually the harm it does. 17 sailors died. They didn't die, all of them, in the direct explosion. Some drowned because the bulkheads were sealed. Some were blown apart. Some had horrific and painful deaths. None of them deserved to die. Another 57 sailors were hurt in varying degrees and bear their wounds today. Some of them behaved with staggering heroism. One sailor, Rick Harrison, while his legs were actually broken, he didn't feel the pain. And in the desire to help his shipmates, just walked on his broken legs to rescue his shipmates and kept going until he passed out about 18 hours later. So these are our heroes. And they paid a huge price. So when the case first presented itself to me in 2002, it arrived this way. I got a phone call. The families of the sailors that died are meeting. They meet regularly. They can't get any answers. How did this happen? And the Navy wasn't really satisfying them. The Navy was trying to cooperate, but they weren't giving them good answers. And they said, there's got to be more to it than that. Can you come and see us? I flew to Richmond. And these were 17 working class families that were clearly 1 year post-death of their loved ones, and they were grieving, and they weren't getting any answers. And they wanted to find out, how did this bombing occur? They certainly understood the Al-Qaeda part of it. They understood the mechanics of the accident part of it. What they didn't understand is, how could it happen? It had to be something bigger than that. It made no sense. What was interesting about the case, what made the case very difficult, was that this had the remnants of a cold file to it. For any of you who watch those TV shows about solving mysteries, well, the government of the United States, FBI Counterterrorism Unit, had been investigating the call, led by a man named O'Neill. Those officers were in the World Trade Center, and those officers were lost on September 11, 2001, and O'Neill died. So that trail was gone, and all the work that sat in the FBI was not available. And bluntly, the FBI had better things to do, so even though they would say, we'll cooperate and give you anything we have, they ultimately didn't have anything. So we thought we would parallel ourselves with the victims of 9/11. The logic being, here's two sets of victims, both of Al-Qaeda. Let's see what happens. But the 9/11 fund would not allow the victims of the cold to be admitted. They thought the congressman we visited with, thought it was a really bad idea to open it up to American servicemen who were actually injured in service and create a further fund. Even though on 9/11 there were armed services personnel that were killed at the World Trade Center that day. So that truly turned out to be the second dead end to help them. So the only thing that was left was to actually try to figure out who planned this thing, who did this. So we started investigating and started making some phone calls. And I'd love to tell you this was a genius moment, but it wasn't. It was one of those things that happens in life. I was in New York. It was a Sunday. I was invited to go to a dinner, and one of the guests at that dinner is a man named Steve Emerson. Steve Emerson runs the investigative project in Washington, and he considers himself an expert on terrorism. He is. And while we were having dinner, the host said, "Steve, maybe you can help Andy. He's trying to figure out what's going on with the coal." And Steve said, "Oh, that's Sudan." Well, my dinner ended with that moment because it was such a surprise. And I said, "Why do you say that?" Well, he said, "Well, I don't know, but it just had to be." Well, what makes sense is, Andy, I just follow this. It just had to be. But if you want to talk about it some more, let's call him. So a week later, I flew to Washington and met with him. And he introduced me to a man named Vince LaDonna, who is now, I believe, at Tufts. Vince wrote his graduate thesis on Sudan. Now, his graduate thesis stopped in 1996 in the sense of the information covered, but it covered the period from 1988 to 1996. And that was a tremendous beginning, because what it told me were several things that I didn't know. First of all, after the Afghanistan-Russian war was over, Saddam Hussein was essentially expelled from Afghanistan. His presence wasn't needed, and he needed to find a place to take the beginnings of what became Al-Qaeda and find a safe haven so it could grow and build. He was persona, even though he was from a prominent Saudi family, the royal family of Saudi Arabia didn't want him back because he was regarded by the royal family as trouble. The reason he was trouble was because he was adamant about the fact that Western influences were corrupting Saudi Arabia. It shouldn't be happening. In 1988, Sudan had had a coup d'etat. Interestingly enough, I don't want you to get the wrong message on this, Dean, but the coup d'etat was led by the dean of the law school. So, but I suspect there is a significant difference there. But it was a coup d'etat, and the idea was to create a new government in Sudan that was a theocracy, that would replace the existing body of law with Sharia, which is the law of the Quran, have a very strict Muslim perspective, and to basically create a pan-Muslim movement throughout the world that would resist what they call the Crusaders and the Zionists. And this was a perfect place to invite this poor country, to invite Saddam Hussein and to bring all of Saddam Hussein. Right idea, wrong case. But to invite Al-Qaeda and its leadership in. That invitation was made. So as a result, Al-Qaeda, top to bottom, made their way to Sudan. But there's a lot of money involved in that regard. And just to give you an idea, the purpose of the invitation was to basically create a place where there would be a center where virtually the entire terrorist organization throughout the Middle East could meet regularly, plan regularly, get financial support, get munitions, train. That was the idea. So as a result, Osama bin Laden relocated, and he invested his assets substantially in several different areas in Sudan. The first thing that he did, and part of the commitment, and this was the State Department in the Global Patterns of Terrorism, said that bin Laden agreed to help Tarabi, head of the government, in the regime's ongoing war against the African Christian separatist movement, we know that as the Darfur events today, and to invest in the infrastructure. So what he did was he arrived with his wealth and with his organization, and he basically formed a total of 6 companies. Those companies did, among other things, first of all, they organized a bank in Khartoum. Now, the bank was under the Muslim banking system, so it didn't lend in the traditional sense because the taking of interest is not permitted. So a bank in that context looks more like an investment bank in the sense that investments are made on one day and you are obliged to buy the investment back on a future date at a different price. And that disparity is essentially the reward of the investor. So it looks like it's an investment. In reality, it's a loan. It really doesn't matter. Because $50 million went into that bank of Osama bin Laden's money. He built the main road between Khartoum and Port Sudan. He built the airport. He revitalized the agricultural industry and owned most of the major corporations. Wasn't doing it for good business. He was doing it largely to create 2 things: cash flow and cover for Al-Qaeda. Cash flow is obvious. The money as it came out was now available in a bank for use by Al-Qaeda's operatives. And cover because he had a legitimate reason to be there. And now the operatives had real jobs and real stories and cover stories, and that worked. So that became very important. Then obviously I told you about the twice a year there were meetings of the entire, it was literally the Paris Air Show of terrorism. And according to the CIA, they would come together and they would literally plan all these events of terrorism twice a year. Beyond that, however, there were 3 training camps that were created just for Al-Qaeda in northern Sudan. The radios that were used, the techniques that were used, the munitions that were used were all provided by Sudan's military. And all this information came from what had been secure information that was provided by, for example, the Canadian equivalent of the CIA. They allowed that information to be delivered to us, and we were able to use it. Then we found out some more interesting things that really were that kind of tied the thing together. First of all, Osama bin Laden issued 2 fatwas, one in 1992, one in 1996. Very important. The first fatwa was very specifically, it was the duty of every Muslim to attack every Western influence on the Saudi Peninsula. That includes Yemen. And to take whatever lives of the crusaders, referring to the Western influences that were there in order to eliminate their presence. That gave a religious justification to Al-Qaeda and called on all other Muslims to provide them with support in their deeds. A second fatwa was issued from Sudan in 1996 to the same effect. And then there was the diplomatic cover. And that part of it was particularly shocking to me. Now, what I mean by diplomatic cover are 3 things. And what's interesting, of course, is we all know about the bombing. We just don't know about these other things, and they are absolutely staggering. First, diplomatic passports were issued to Al-Qaeda operatives. 200 passports were given to Al-Qaeda to use as they wanted in 1998. Those passports are good for between 5 and 10 years, which meant that an Al-Qaeda operative was free to pass through any border in the world without being stopped, searched, or questioned. No customs, no duties, no immigration. And that allowed Al-Qaeda to basically train someplace and go someplace else to execute the event. Hugely important thing. Second thing is, they were given access to Sudan's diplomatic patches. Now, Sudan was allowing Al-Qaeda to ship whatever it wanted to in a diplomatic patch, which was also free from examination. That became particularly important in the Cold because The explosives that were used were the identical explosives that were sent to Yemen from Sudan in a diplomatic pouch. It's impossible to prove that it was the exact same batch, but it was certainly the exact same type. And that was enough. And then the third thing, which had nothing to do with the coal, but had everything to do with how terrible this would work, is the fact that the Sudanese embassy in New York was part of the escape plan for the World Trade Center bombers in 1993. And those documents existed. So they were allowing their diplomatic missions, in this case the UN mission of Sudan, to be corrupted as a tool of Al-Qaeda. Now all this became important because we had to prove in a court that not that Sudan was cooperative to Al-Qaeda, that wouldn't have been enough. We had to prove that Sudan actually rendered material support for this operation. That was the burden that the DC Circuit put on us when we basically took the case up on appeal and it came back down. And this is how we were able to meet that burden. Ultimately, I presented all this information to Jim Woolsey. Jim Woolsey was a former director of the CIA from, I think, 1994 to 96 during the Clinton years. And I laid it out, and he testified. And his statement was that it would have been impossible for the coal to be bombed without the active cooperation of Sudan, and it was the only nation that was in a position to provide the type of support that was provided that led to the bombing. So we now have that evidence to offer. We then ultimately found the last piece, which is when in doubt, follow the money. So I'll just talk about that. With the decline of the former Soviet Union, a lot of Soviet resources were sold into the private market, and a lot of things happened with them, one of which was that there was a triangle created. And the triangle involved bloodstones from Sierra Leone that were taken to Antwerp, cashed in for money. That money then went to Sudan and was used to support Al-Qaeda. And some of them would then continue the route again. And that was run by a man named Victor Buto, who was a Russian who's now in jail for this and other things. So that last piece of information, for those of you who saw the movie with Leonardo DiCaprio, well, when I saw that movie, I said, oh, that's interesting. And I ran into the guy that wrote the book, who was a Washington Post reporter. We were talking about this thing, and I said, we were talking about it, and he said, and the money ran through Sudan. And I said, oh, bingo. Are you sure about that? Yeah. Do you have your notes? Yes. Would you mind testifying from your notes as to what your conclusion is as an investigative report? He said, be glad to do it. And that was the last piece of the circle I needed in order to link it. And with that, we went to trial. In the trial, we presented the story and everything I've just told you. It's all in a written opinion if you want to read it. It's fascinating reading. And now we had the first judgment. Now the first judgment was just for the families of the 17 that died. But that was a bad judgment. And here's why it's bad. In 2004, the DC Circuit, in a case called Scipio, ruled that the Foreign Sovereign Immunities Act was just jurisdictional, created no cause of action. So you had to find your cause of action from some organic law that existed in the United States. So you basically be arguing, and the court went on to say, we'll use U.S. law of the state of the decedent or the sailor as the proxy for what the law should be. Now that created a legal fiction that was something short of ridiculous. But it's all you had. And that or nothing, we took it and we ran with it. But if you have a death on the high sea, there's a federal statute that preempts all claims, called the Death on the High Seas Act. I know we have a torts professor here who's undoubtedly well familiar with that statute. And that statute has a couple of problems in it, not the least of which is it was created in 1920 in order to create a wrongful death remedy when no wrongful death remedy existed for the American maritime industry. And it was a compromise. And it basically said, we'll provide you with support for your family, that is, say, the amount of money it takes for you to live now that you're gone, but nothing more, nothing for your death, nothing for pain, suffering, all the things that we tend to think of as the traditional wrongful death case. So in the first case, we had that limitation, and as a result, the award was $14 million for the 17 lives, which I thought was terribly inadequate. Now here we had this, but in 2008, a new statute was passed, becomes very important in this world. And that statute now created, for the first time, a cause of action for terrorism alone. It would be a federal cause of action, and not only that, but the claim existed not only for the person who was the victim, but it recognized the fact that terrorism is designed to affect the free will of entire body politic of people affected. So consequently, not only is the victim allowed to sue, but all the relatives within what Congress regarded was the appropriate circle, including brothers and sisters, adult brothers and sisters, amazingly, fortunately, parents, grandparents, anybody with special support, and obviously children. The law came in 2008, but the judgment on the coal was in 2006. So here's the next challenge for you. You would have the right to convert your judgment into a 2008 judgment under the new law. But that meant that you had to give up your old judgment. And Sudan only had $20 million on deposit in the United States. And there were about 15 other claims out there. So we lost our place in line. I might have had more money on paper, but actually no money for the people. So we made a decision that we would try to do both, but we weren't going to give up our judgment. So that's what we did. And we executed on the first judgment, and all the people that had that judgment were paid in full. Now we had another group. Here are the people that are left. There were the people that were not within the coverage of the Death on the High Seas Act, which had sued, and under the new law was created, we had the right to sue for them, and it was our position that a law and body of law supports the Supreme Court has said that when there is a statutory change in the law after a judgment that creates a cause of action when none existed, there's no res judicata bar as to that new cause of action. What was it? Wow. Problem solved. Except for my friend Robert Duvall, who's the United States District Judge in Norfolk. And Judge Dumar had a slightly different perspective of it. Judge Dumar said, wait a minute, there's a serious Article 3 question here. I got a judgment, and nobody's telling me that my judgment is no good. So it's nice that you have the right to amend, but not in my courtroom. I'm barring your case. I can't give you the answer to that. I'll let you know sometime after March 22nd when I argue that in the Fourth Circuit. But I think that part of it will be repaired then, because the body of law is pretty safe on that. Now we have the victims. I have to confess with you, unfortunately, it's a closed group, so I can share a moment of truth. I wasn't going back to Judge Dumar with that ruling again. So when we filed the case for the victims, we filed that one in Washington. And Judge Lambert, who is the judge that writes, we fortunately drew him, and he's the judge that writes probably the most favorable opinions on this. And he ultimately awarded for the sailors that were hurt $319 million. And now we have to find the money. So I'll give you another private story I'll share with you. About the time that we got that judgment, I got a phone call from the ambassador to Washington from Sudan, who invited me to lunch at the embassy to talk about things. Now, I want you to know that that was one of those great moments in which my wife and I had a sharp disagreement on what my responsibility was. My wife took the position, are you crazy? That's Sudanese property. You're never coming home. You can't go. I took the position, I said, what do they care about me for? I'm just going to do what I need to do. And fortunately, my wife ultimately said, I can't stop you, so call me and let me know how. So we had our lunch. And throughout the entire lunch, he kept on saying, we're poor people. I said, yes, you are. But you're selling 350 million barrels of oil a year. I'll be glad to work something out. We haven't worked it out yet. So that's kind of where we are in that case. And now we come to the back part of this thing. How do you get paid? And that's another story, shorter story, but just as profound. And it goes back to the very first case. Yesterday, I had the pleasure of sitting in on a class involving national security. It was a great class. Terrific students, great professor. I figured I owed you some money for sitting in that class because I found it that interesting and that informative. But we got to talking about the idea of a presidential waiver. You know, does Congress have to give the president permission to put a waiver in of an act of Congress? And that was the question. I probably was not all the time because it happened to me. And after we got our judgment in the Dallaberti case, first thing that happened was we realized that all the frozen assets in the United States could not be attached because the president had waived the right to execute on a judgment. So he effectively created a pocket veto on this right that we had. And that really bothered me. So I filed another lawsuit against George Bush, and Secretary of the Treasury, Secretary O'Neill, and some other people. And about that time, we also started lobbying Congress, and the Terrorism Risk Reinsurance Act was passed that repaired that so that by 2002, we were able to get past that burden and get people actually paid. But there were still major problems. And most of those problems ultimately were cured. And so there's a difference between acts of terrorism and execution and the rest of the body of law dealing with sovereign immunity. So let me just walk through it. It takes 1 second. It's very simple. In section 1609 of the Act, it says that all property of a government, foreign government, remains immune from execution unless it fits into an exception. So you start with the answer, the first premise is no. It's kind of like growing up in my house. I talked to my mother, the first question was no. Didn't matter what the question was. So in any event, but then section 1610 and 1611 give you exceptions. And most of us know that the first one typically is the commercial exception, where the government's engaging in a commercial activity, the assets that are used for a commercial purpose are available for execution. That one's easy. But largely, it became impossible in the mechanics of it because governments don't normally contract in their own names. For example, they create government-owned corporations, and those corporations theoretically act, it's quite theoretical, act separately from the government and therefore have a juridical separation, according to the Supreme Court in 1983 in a case involving Cuba. So the presumption is you can't reach those assets unless that's the entity you were doing business with, unless you can prove that that entity was controlled entirely. Here the word we hear is entirely by the government, or alternatively, well, it would be a fraud or an injustice not to allow execution. And that 1983 case pretty well spelled the death knell for the ability to execute against most governments when they didn't want to, because they know how to structure themselves. So that while it sounded pretty easy, now it got very difficult. And then if that weren't enough, whatever was left typically found itself in one of two places. it was either held by the United States for the benefit of the foreign government, so you had the government of the United States having its own sovereign immunity, which it would never waive, even for a victim of terrorism. And then finally, you have the last point, which is, of course, in the event that you're dealing with a state sponsor of terrorism, there are still things that they can do, but you have to have a license from OFAC, and those assets can't be executed against unless OFAC, the government, gives you permission to execute on that same asset, which isn't going to happen. And that was the landscape until 2008, sorry. In 2008, with the passage of this repair statute, they also repaired the execution procedure. And they stripped away the Supreme Court decision as to victims of terrorism. So if it is the government or it's an agency or instrumentality, it doesn't matter if it's a corporation. If they're associated with it, you get it, end of story, period. That's all stripped away. And the last part of it is, and if those assets are held by the United States, too bad, you get paid those too. Now, I was told that you ought to let 20 minutes go for conversation, so we're right about there. So I will tell you, because you're going to ask me, well, what does that mean? I get to give you the perfect lawyer's answer. I don't know. And the reason I don't know is because I'm about to use all of those tools involving Cuba. So stay tuned, invite me back in the future, and I'll tell you what happened. Thank you.
So you said the first judgment, Sudan only has $20 million of assets in the United States, but then it seems like the Sudanese ambassador is trying to get you to bring down the $319 million judgment. Is the money even there? Why is he even worried about that $319 million judgment? And second question, do cases like this then prevent countries from investing in the United States that have no reason to?
The answer is, number one, it is a dynamic, ongoing thing. So consequently, the $20 million was the amount on deposit in 2006, which is when we started executing. Time changes, that number changes. For example, we received 14 million of that. So you would say, well, that leaves 6 million left. But the reality is more money flows in every day and is captured within the rubric of the frozen asset issue. But the second thing that happened is oil. Sudan signed an agreement with China, allowing China to use Sudan to explore for oil. Guess what? They got it. They found their oil. 350 million barrels a year. Here's now the next little complication. That oil field is actually located in South Sudan. Bad news, right? Because you say, oh, that's terrible, because they're not Sudan anymore. Or perhaps they're not. That's still an open issue as to the oil fields. But they have no way to get the oil out of Sudan, South Sudan, because that's a landlocked nation. So there's no place to take it. And in order to build over the mountains to get the oil out of Sudan, the estimated cost is somewhere around $300 billion, and it'll take 15 years to do. And because oil keeps pumping and you can't store it, they got to get rid of it and sell it. So they have to use the existing pipeline. So it has to go to Sudan. Now it has to be sold to China. It goes into a bank. Therefore, I'm okay. Now, the second question is, will it discourage a country from doing business in the United States? I hope so. That's exactly the point of a sanction. And this gets into the class on international law that you're taking, because yesterday I sat in on a class involving trade regulation with Professor Caruso. That case was talking about trade regulation and things like anti-dumping. They were exploring, how do sanctions work? One of the sanctions, the ultimate sanction, is an exclusion from being able to do business with the United States. Now that's what a state sponsor typically has, the exclusion from doing business within the United States. in either direction, subject to limited exceptions. Now, most of the world wants to have a trading relationship with us for all sorts of reasons, whether it's technology, whether it's product, whether it's an end market for their goods. They want to be here. And so the price the United States usually exacts for that relationship is, you stop being a bad boy, you start behaving like for the rest of the community of nations, and you're welcome home. And typically a condition within that resumption of relationship is the discharge of obligations like the ones I work for. Okay?
Anybody else? Yeah.
Well, it's possible that these same principles can be applied against the United States or against some of its allies in other countries. Obviously, there's an imbalance in trading relations, so it may make that difficult on simply economic grounds. But certainly, in principle, many people feel that many actions, such as the U.S.'s '98 attack in the Al-Shifa pharmaceutical plant in Khartoum, is an act of state terrorism with victims. Don't have standing in the United States to sue, because Sudan is practically a stateless society anyway, so it would make it difficult for them to oppose such law. But in the future, that certainly that could be turned around against us.
Absolutely. And what happens, the United States' entire position regarding the issue of sovereign immunity goes back to 1952. And in 1952, the State Department promulgated a position which was essentially that there was absolute sovereign immunity for every nation unless the State Department determined it wasn't going to be allowed to be. And it was done exactly on the concept that you're talking about right now, which is largely to protect U.S. interests. What the United States found over the next 30 years was that that concept didn't work because around the world, in courts around the world, our sovereign immunity was uniformly being rejected, which led to the 1976 passage of the Foreign Sovereign Immunities Act saying, well, these are the places where our immunity is being rejected, so therefore we're going to allow our citizens to have equal footing because you've rejected, so we feel okay. Then that's where it stood and was pretty stable as a body of law until 1996 when we got into the area of terrorism.
So, Andy, what's on your schedule the rest of the day?
I get to talk about, I'm going to a class right now where I get to talk about a case that I lost in the United States Supreme Court. So it's going to be a painful afternoon for me.
Excellent. Well, we'll still be here for a few more minutes if people want to chat with Andy